Joining us now in studio, Professor David Levine from UC College of Law, San Francisco. Great to have you on board, David.
Thank you.
We've seen the filing. We know the charges. Has the DA built a strong case here? Has the DA built a weak case, specifically when it comes to substantiating the 34 felony counts?
He's built a pretty strong case, Mike. He gave us a lot of detail because one document was just perfunctory. It's just these are the numbers of the New York State law. But it's that statement of facts that gives us a lot of detail. And then the way Mr. Bragg laid it all out in his very detailed press conference, we have a very good idea of where he's going. Now, it does say 34 counts, but a lot of that has an element of repetition to it because each time Michael Cohen sent in an invoice for a bill that is part of this scheme, supposedly to hide the payments, that is a count. Every time Mr. Trump signed a check, that's a count. And every time they entered it in the books of the Trump organization, that's a count. So there is a certain amount of repetition there. On the other hand, those facts are quite well established. We have Mr. Cohen's testimony. We have the canceled checks. We have the Trump organization's documents. So we know all that. The stretch, and I think it's doable, but the stretch is, do we turn those misdemeanors, false documents, into felonies? And the way to do that is by showing that there's an intent to defraud and to commit other crimes. And what Mr. Bragg has said is that it's a combination of state tax law, state election law, and federal election law.
Okay, so he's tying it into what you said, just those multiple things. So what is the underlying crime here? Did he articulate that in the court proceedings today?
Well, the underlying crime in the state of New York is false business records, and that's why he's pointing to the checks that were used for false purposes, the entries in the Trump Organization books, and for that matter, entries in the books of the American Media Incorporated, which runs the National Enquirer and was part of the payoffs for 2 of the 3 people who are mentioned in the documents today. So that's the number one underlying offense. Now, that in and of itself in New York is just a misdemeanor, but what Mr. Bragg's attorneys have done, the district attorneys have done, is to say this was in furtherance of fraud and in furtherance of other crimes, and that's what elevates it to a felony. Now, a low-level felony, we have to keep it in context. In New York, this is the lowest level felony.
Any early motions coming forward, you think? A change of
yes.
venue? Does this even go to trial?
Well, I think we're going to see motions. Now, they scheduled that, right? There's 4 months for Mr. Trump's attorneys to look over the information that they will be given as a matter of right from the DA's office, and then to file motions. So will there be a motion to ask the judge to step away? A motion to change venue? Mr. Trump has said he'd rather be in Staten Island, where he knows he's got a lot of supporters, rather than Manhattan, where he doesn't have that many supporters, according to the votes, that sort of thing. And then the more substantive motions will go to the question of whether the New York DA has gone too far in trying to marry, particularly federal law, federal election law, to some of these offenses that otherwise would be misdemeanors. That's going to be really, really important.
All right. So, yeah, we'll let that be the last word. So much to wade through today and so much to unravel with all this. David Levine, always good to see you. Thank you.
Thanks
for
for having
Professor.
me.